Welcome to Womblebond Dickinson's series of intellectual property top tips. Here, we aim to provide useful guidance on how to protect your investment and innovative efforts through intellectual property rights. Intellectual property, or IP rights, can help you protect your products, designs, brands, inventions, and even creative works. In this installment, we will take a look at how you can protect your inventions in the United Kingdom and in the United States through obtaining a patent.
A patent is a registered right granted by the Patent Office. Where a patent is granted, the patent owner is awarded the exclusive right for a limited period to use the technology underpinning their innovative products or processes in return for revealing their inventions to the Patent Office and the public, and thus adding to the pool of human knowledge.
Thus, patents are a way of encouraging development by giving inventors the exclusive right to exploit their invention commercially, either through making the product or using the process themselves, or granting the right to others in exchange for a royalty or fee. Patents are territorial, meaning that the rights are limited to the country or geographical area in which the patent has been granted. This means that, when you apply for a patent, the laws of the country or area where you seek protection will apply.
So, let's start with the United Kingdom. In the UK, subject to a few exclusions, patents are available to protect products and processes which are new, inventive, and capable of industrial application. A patent will only be granted to the extent that an invention is new. An invention is new where, at the date you file your patent application, the invention has not been made generally available to the public. If the invention has been disclosed or made available before the application is filed, the invention may not be considered new and you may be prevented from securing a patent. It is for this reason that if you think you have an invention that is patentable, it is very important that you keep your idea secret. You can normally discuss your idea with a patent attorney or legal advisor because they will have obligations of confidentiality, but otherwise you should think about putting in place a confidentiality agreement if you need to discuss your invention with other people. Providing that the invention is new, it also has to involve an inventive step. In the UK, this has also become known as the obviousness test. The product or process will not be considered inventive if the invention would be deemed to have been an obvious development over what was known in the field prior to the date you apply for your patent. In simple terms, this is because if something is obvious, it cannot be considered to be truly inventive. If the invention was not obvious to a person who knows about the specific subject area and has expertise and skills in that field, the person commonly referred to as the skilled person, then the invention can be considered to involve an inventive step. In addition to being new and not obvious, the invention must be capable of being made or put into practical use, and must not be expressly excluded from patent protection under the law. In the UK, such exclusions include, amongst other things, discoveries or mathematical or scientific theories, creative works including literature, art or music, computer programs, or methods of treatment or diagnosis in the care of humans or animals.
Now let's look at the US. The Leahy-Smith America Invents Act, which transitioned the US from a first-to-invent regime to a first-to-file system, like that operated in the UK, sets out the requirements for inventions in respect of which you can be granted a patent in the US. This includes satisfying the subject matter eligibility requirement, the novelty requirement, and the non-obviousness requirement. Let's look at each of these in turn. A patent will only be granted to the extent that an invention meets two criteria for subject matter eligibility. First, the claimed invention must be directed to one of four categories: processes, machines, manufactures, and compositions of matter. Second, the claimed invention must not be directed to an exception to the four categories listed unless the claim as a whole includes additional limitations amounting to significantly more than the exception. These exceptions are limited to abstract ideas, laws of nature, and natural phenomena. If the subject matter is eligible for patent protection, the claimed invention must also be deemed novel or new. U.S. laws provide detailed requirements for novelty. However, generally speaking, subject to certain exceptions, a claimed invention will be regarded as novel as long as it was not patented, not described in a printed publication, such as a journal article, or not in public use, on sale, or otherwise available to the public before the filing date of the claimed invention. As previously mentioned, there are various exceptions to the rules, most notably of which, disclosures made by the inventor less than 1 year prior to the filing date of the patent application will not destroy novelty. In addition to being eligible subject matter and novel, a claimed invention must also be non-obvious, whereas novelty is an objective standard. Non-obviousness is much more subjective and is based on a greater number of considerations. The general standard is that a claimed invention will be regarded as non-obvious, provided that it would not have been obvious to a person having ordinary skill in the art before the filing date of the claimed invention. Thus, a determination of obviousness considers not only what is expressly described in other patents and printed publications, but also what would be expected to be generally known to others of similar skill in the field of the invention.
The registration of an invention as a patent can be beneficial to the owner in a number of ways. You can protect your invention even when it becomes known to the public. For inventions that can be reverse engineered, patents are generally the most effective way to prevent third parties from exploiting your invention.
While it lasts, it can act as a lawful barrier to entry against your competitors who must either not employ the technology described in the patent or, if you agree, pay you to make use of your invention.
Your rights are clearly defined on a public register, which can make enforcing your rights against other companies or people who use the technology without your permission less time-consuming and less costly than proving breach of confidentiality or breach of contract claims. If you have an invention which you think could be patented, we encourage you to speak to an IP attorney before you speak to any third party, whether this be a friend, a contractor, a distributor, or even a potential investor.
If you want to know more about protecting your inventions, please contact the intellectual property team at Womble Bond Dickinson. We hope you have enjoyed this intellectual property top tips video. Thank you for joining us.